The Supreme Court decision in the case of MENDAROS and others versus LAZADA e-Services Philippines. The court recognized another classification of employment, which is the fixed term. A fixed-term employment is an arrangement wherein an employee is hired for projects with predetermined completion or in a work where a fixed term is essential and a natural appurtenance of the work. The work performed here may also be necessary or desirable to the usual trade of the employer. In Brent School Incorporated versus Zamora, the court expounded on fixed-term employment. Some familiar examples may be cited of employment contracts, which may be neither for seasonal work nor for specific projects, but to which a fixed term is an essential and natural appurtenance. Overseas employment contracts, for one, to which, whatever the nature of the engagement, the concept of regular employment with all that it implies does not appear ever to have been applied. Article 280 of the Labor Code notwithstanding. Also appointments to the positions of dean, assistant dean college, secretary, principal, and other administrative offices in educational institutions, which are by practice or tradition rotated among the faculty members, and where fixed terms are a necessity, without which no reasonable rotation would be possible. Similarly, despite the provisions of Article 280, Policy Instructions Number 8 of the Minister of Labor implicitly recognize that certain company officials may be elected for what would amount to fixed periods, at the expiration of which they would have to stand down, in providing that these officials may lose their jobs as president, executive vice president or vice president, etc., because the stockholders or the board of directors for one reason or another did not re-elect them. For a fixed-term employment to be valid, either of these circumstances must be proven. 1. The fixed period of employment was knowingly and voluntarily agreed upon by the parties without any force, duress, or improper pressure being brought to bear upon the employee and absent any other circumstances vitiating his consent. Or 2. It satisfactorily appears that the employer and the employee dealt with each other on more or less equal terms with no moral dominance exercised by the former or the latter. Fixed-term employment arises only in special cases where an employee has bargaining power with the employer in view of his or her special skill. This presupposes that the employee is more or less on equal footing with the employer. In the case, LAZADA failed to show that petitioners actually negotiated the terms and conditions of the agreement on a level that was approximately equal with LAZADA. That petitioners could not have individually bargained for the contract's terms and conditions is shown by the fact that the agreements were similarly worded and applied uniformly to all of them. Moreover, petitioners' work as writers did not require any special talent or skill for them to be distinguished from other workers and be accorded certain bargaining power. And given that the delivery of the items purchased is a usual and continuous activity in LAZADA's business, it failed to show that petitioners' one-year term of employment was essential and a natural appurtenance to their work. Finding that petitioners were regular employees of LAZADA without a fixed term, LAZADA's act of removing them from work after a year, without just cause and due process of law, amounted to a legal dismissal from employment.